And welcome to this week's webinar from Thomas Westcott. This time it's on our newly launched service line, Business Resilience and Protection. My name is Patrick Tigwell. I'm a general practice partner at the firm in their Exeter and Tiverton offices. And again, if you've tuned into these webinars in the past, I'll be a fairly familiar face. It's my honour to be your host for this afternoon's webinar. This new service line, Business Resilience and Protection, has really stemmed from our thinking that business owners are using the COVID pandemic really to firstly take a breath and reevaluate areas like shareholders agreements, life cover, wills, etc. And secondly, the seriousness of COVID has encouraged business owners to think about those dreaded sort of, what if scenarios. So it is sort of very well timed. To discuss the issues, we've assembled a formidable panel that you can see before you. We have the brains behind the idea, Andrew Brown. Now, Andrew, Withy and Andrews, they head up our Thomas Westcott Financial Planning, and obviously they've been the driving force behind this. We'll then pass to my Exeter colleague, Chris Hill, who will be revisiting that old question of whether businesses should be incorporated as a limited company or an LLP or not, and examining the protection those sort of vehicles benefit. And then I'm delighted to welcome our two guests for this afternoon's webinar. Both are from well-established Bristol firm Greg Latchams Solicitors, and I did like it in their About Us page. This is where I embarrass them. It says, and I quote, "Our solicitors have personalities and we make sure fun has a place in business and personal dealings. We aim to be a pleasure to work with and work for." So I think for a firm of solicitors to say that, I think it's, I think that's really quite nice actually. So yeah, so I'm into that. Our first guest from Greg Latchams, and boldly going against outdated chivalrous concepts of women going first, is Paul Hardman. Now, Paul's got 30 years experience. He heads up their corporate and commercial department, and he deals with management buy-ins, buyouts, shareholders agreements, corporate finance work, mergers and acquisitions, that sort of thing. I was also amused that one of his testimonials refers to him not only as a charming individual, but a talented lawyer with a keen sense of commercial acumen. So having a solicitor who has that, I think, is really very valuable indeed. Secondly, and this is your turn now, Helid, I'm very pleased to welcome Helid Wynn, who heads up Greg Latcham's long-term and elderly care department. She provides full consultancy services with regard to estate planning, long-term care and asset protection, and specialises in making applications to the Court of Protection on behalf of those who lack the capacity to obviously do it for themselves. And her clients range from business owners to private individuals. She's also a member of STEP, that's STEP, not STEPS, so she's not H or Claire. And one of her testimonials, thank you for that, Andrew, says that I would also say that Helid has a very approachable and understanding manner and is able to give valuable peace of mind, as well as being very candid about what is and is not likely to be achieved. So I think that's a very nice comment too. And finally, in the intros, I'd like to mention Jamie Giles, who's just managed to mute himself and take himself off camera. Jamie's our head of marketing, and he's here to ensure the webinar goes smoothly. He's also recording it, so he'll be recording it and sending out a recording of that to every one of you this afternoon on the email. We've allowed about an hour today, so finish at about 3 o'clock or so. So there'll be lots of time for questions. Some of you have submitted questions already as part of the registration process, but if you haven't, don't worry, you still can. The button there, the Q&A button, just put your question there, put anon if you don't want your name read out. And if you get to the end of the webinar and you still like to ask a question, you still can on events@thomaswestcott.co.uk. So I would just say that, the questions, we can't really get into the weeds of people's individual affairs particularly, but we will answer them possibly in due course in a couple of days or so once we've got all the facts. And if you're a client of TW, your usual partner will probably be that port of call. So without further ado, I'll hand over to Andrew for a bit more of an explanation about the new service line of business resilience and protection. So Andrew, over to you, please.
Patrick, thank you very much, and welcome to everybody. Thank you for joining us this afternoon. Yes, this service is something that's hopefully a very timely addition to our kind of suite of client services, and it's really a reflection of the current mood that we're sensing in the business marketplace, where people are in reflective mood. Some of our businesses have had a pretty torrid time, some still are. Others are kind of bouncing back fairly quickly, particularly in sort of hospitality and the holiday trade. But yes, it's certainly making people reflect and think, and perhaps consider the too difficult pile, and maybe looking at some of the things that they all know they need to consider, but they're always too busy just running the business to get around to doing it. A particular case study I'll mention very quickly is a long-standing client of ours who started his business from scratch, built it with his wife to 26 employees. They have a electrical and plumbing and engineering business, incredibly profitable, very successful, but the chap had no life at all. He hadn't taken time to work on his business. He was working 100 hours a week, working far harder than any of his employees. It just really got it all wrong, I suppose, in one sense. And so he approached us for some help with strategic planning, coming together with a package of changes that would create proper structure within the business. So that included changing its structure to a corporate entity, a limited company, putting in place proper agreements, proper protection provisions, proper management structure, remuneration structure, all of those things over a period of 18 months we've done. He now works 3 days a week. He's never been happier. He's making as much money as ever, but just has a completely different, more lower risk approach to running that business. So that's kind of what this is all about. There is a flyer, a leaflet, which we're going to circulate to all of those of you who attended this seminar, and we're also going to put it's on our website under publications. Patrick, if you'd like to just quickly screen share it, I'll give you a sneak preview of the fact sheet, which covers the main areas of the service.
Start at one.
Snappily entitled Business Resilience and Protection Service. The idea is that it's 10 key areas that we, in our experience, believe that business owners need to address, that kind of brought together will provide them with some pretty comprehensive reassurance that they're in a better place than they were before they started the process. It's not an all or nothing service. We're quite happy to talk to clients about individual aspects of it, or we're happy to provide a proper overarching review of their position. So the 10 key areas, which I'll flick through very quickly. The first is a very clearly business structure. Should you be incorporated? That applies to sole traders and also to partnerships. If you are a partnership or a limited company, you need a shareholder agreement and a partnership agreement. What on earth happens if somebody does die or falls seriously ill? Vitally important that that's in place. That then follows that, again, if you have business interests, you need to have an up-to-date will and you need to appoint attorneys, because again, what on earth happens if you're out of the country playing golf or if you suddenly suffer a catastrophic illness? And then a whole suite of areas of protection that I shall touch on later on, which bring everything together, provide funds to pay out a deceased person from the business or cover critical illness insurance, deal with what happens if a key individual falls ill, make sure loans are repaid in the event of something happening, and also some nice freebies, some ways of getting tax-free benefits from your company without a P11D benefit, in particular personal life cover. And then finally, I'll touch on things like private medical insurance, how you replace your income if you're sick, and of course, if something happens to you and you fall critically ill. So that's the gist of the service. It's pretty comprehensive. Most of it we offer within Thomas Westcott. We also work with our legal colleagues for certain aspects of the service to make sure that it's all joined up. And really joined up is everything that Thomas Westcott is about, a one-stop shop service for a business owner. So if you want to unscreen share, I'll shut up, and I'd like to pass over, if I may, to my partner, Chris Hill.
Yeah, Chris, over to you.
Thank you very much. I shall also attempt a screen share. The one slide. Yeah, my little topic is really just touching on the first of the items that Andrew mentioned, and looking at the issue of incorporation of a business. So we're here looking at a situation where possibly a sole trader or a partnership, quite often small businesses start off in that form, but as they grow, there does come a point where decisions need to be made about the future structure and best structure for that business. Now, in general terms, the things I'm going to touch on here would apply whether you're looking to convert a business into a limited company or an LLP. I probably will predominantly refer to a company because that's typically where the vast majority of incorporations are. But most of the issues I touch on are relevant to both, other than the tax aspects where there is a bit of divergence. So I thought I'd just split it quite simply, a list of advantages, a list of disadvantages. This is pretty high level stuff. You could sort of dig down into the detail behind some of these a little bit more, or quite a lot more in certain instances. So the starting point, and really the thrust of what we're talking about here, this is about protection. And you start a business, you're operating as a sole trader. What you haven't got is a split between a business owner's business interests and their personal interests. Were something to go wrong in the business, you know, it could be something like some sort of uninsured loss or claim, or you know, we're in turbulent times. You know, it could be issues around the business hasn't done very well, and when we get into an insolvent sort of position, then the individual's personal assets are at risk of any claim from creditors. So really, it's about putting in place a split between the two, self-contained there in terms of company with the business interests and personal interests, sort of savings, investments, a house, everything like that is sat separately. There are exceptions to this, you know, even with a company, which I'll touch on a bit later with the disadvantages, but that's the basic principle of what we're trying to do and what a company seeks to achieve. Other issues that are relevant when making that decision, it might seem a bit of a strange one, but there is a general perception that a limited company is a business of more substance than an unincorporated business, a sole trader. Now, the reality is, it comes down to the individual and how they're running the business, but that isn't how it's perceived. And so it could very well work to one's advantage if you are seeking to sort of grow your business to be in a corporate structure as opposed to operating as an unincorporated business. The tax angle, this is one of the areas that, you know, I could spend a lot of time on. I won't, because we haven't got the time. There's probably two things just to focus on here. There are ongoing savings. If you run a business and you take your profits out in full every year, there are tax savings to be had from operating in a corporate structure as opposed to a sole trader. That has changed over the years. Certainly the savings are nowhere near what they have been in the past on certain occasions. And I can sort of sit here and tell you what the savings are today. Tax legislation, tax rules change on an annual basis, so this is forever a bit of a moving feast. But just to give you a rough idea, a business that's making about, say, 25,000 of profit, there's potentially about £400 of tax saving per annum to be had operating as a limited company as opposed to a sole trader. Now, actually, in my view, as someone advising people on the business structure, if you're looking purely at that aspect of it, it probably isn't worth incorporating at that level. There are other issues to consider, I appreciate that. But with the extra costs associated with running a company, that sort of saving will quite easily be lost. As the business grows, as profits grow, then the savings do increase. So it's sort of 35,000 profit, we're talking about £800 a year of tax saving. You get to 50,000 profit, and it's in the region of £1,400. So it is very relevant. The other thing to consider is, as well, if your business is growing in particular and you're not taking all your profits out of the company or out of the business, with a sole trader, if you make £50,000 profit, you are taxed on £50,000 profit. even if you only take out £10,000 from the business as drawings in that year. With a company, you are able, it acts like an envelope in terms of your earnings. You know, you can generate the £50,000 profit, but if you're reinvesting in your business, then the tax rates for that reinvestment effectively are lower and better than if you were operating as a sole trader. So there are advantages from a tax angle. With a company, all companies have to be registered at Companies House with a name, an appropriate name, and no two companies can have the same name. So there is an element of protection there from in terms of protecting the trading name of your business. It isn't that cut and dried. I mean, if you're really looking at protecting the name, you've then got to start delving into trademarks and getting the name registered as a trademark. But again, it's an issue to consider when looking at this. The corporate structure here in the UK is very simple. It's very transparent. It's low cost. It's not difficult to set up a company at all. You know, you do see adverts for cut price incorporation of companies. What I would say, however, is this is the opportunity to get your structure right. So it's really not just looking at getting the company set up and getting on with it. You know, you need to make sure you've got the right people as directors. Where's the registered office going to be? Directors need to have a service address registered at Companies House. If you're operating your business from home, then, you know, again, there's something to consider there. Do you want your home details on the register at Companies House? There are ways around it. You need to make sure you've got the right shareholders in place. If you're looking to sort of maximise the tax breaks and advantages, if you're married, you know, is it going to be an advantage for your spouse to be a shareholder in this company? And then you get into sort of more complex areas, possibly looking at what we call alphabet shares. You have shares in the company with different rights. So you've then got flexibility around the ownership of the company and who gets income from the company. So quite a few things can get thrown into the mix when you're looking at the setup of a company. Practically, something that I do see a lot of larger businesses will not deal with an individual or a sole trader. A lot of this really revolves around employment status issues. If HMRC were ever to deem that individual actually should have been an employee and not treated as someone who's self-employed, if you're dealing with a sole trader, the liability associated with that in terms of any tax and national insurance that may be due will fall on the employer. When you're dealing with a company, or when they're dealing with a company, the obligation sits with that company. So from the risk management of a larger business, they do generally much rather deal with a corporate than an individual. And okay, we're in a situation here where perhaps you've not even set up your company yet, but this again is longer term thinking about getting the right structure. When you come to sell your business, if your business has grown, it's got lots of contracts, it's got property, it's got leases, it's much simpler to deal with a sale of that business being the sale of the shares than the sale of the constituent parts of the business by selling individual contracts. You've then got the issue of going to suppliers and customers and renegotiating contracts and the like. So again, longer term, a lot simpler in dealing with an exit from a business if you're operating through a company. So that sounds all nice, great, it's rosy, but there are disadvantages. You know, we've got to be realistic about that. There is more information in the public domain. I've mentioned Companies House. Information will be on the register. It could be personal in nature unless you are using a service address. Having said that, that also has its positives. If you're looking to get credit, the fact that you're a company and you've got a track record at Companies House will actually help you compared to a situation with a sole trader. There is quite a lot more in the way of administration and compliance required around a company. in terms of its obligations and filings, particularly again at Companies House. One of the sort of perennial battles that we have with clients, or some clients, is sometimes trying to get across the message. Actually, the money in the company isn't yours legally; it's the company's, and there are rules and there are restrictions around what you can and can't do in terms of how you get the money out. There are things you're supposed to do when a company lends money to a director and things like that. So again, there's more procedure around the way that a company operates. Directors have an obligation to comply with the Companies Act. They are required to act in good faith, and they should be promoting the success of their company. I haven't written it there, but also things like the Insolvency Act. Directors, again, have got to be careful, particularly things get a bit sticky, that they are not seen to be wrongful trading. And this is sort of one of those situations where the corporate veil can be sort of breached, because if a director has been wrongful trading, then they become personally liable for losses incurred during that time. And finally, again, this is another one where the ability to protect yourself can be restricted. Quite often, again, particularly with a new company, you may well find that suppliers, banks, landlords may require personal guarantees from the company directors. So that's certainly to dilute the benefit of operating as a company. You will find as time goes on, as the company becomes more established, that will probably start to fall away, but it is something to bear in mind when you're sort of assessing the situation. So I think that's pretty much it for me. So back to you, Patrick.
Okay, yeah, thanks, Chris. And touching on, obviously you've done the points you've made. The question we've been asked is it more expensive to operate as a limited company than a sole trader? And if so, I guess you need to, as a business owner, you need to factor that into your calculations of tax saved versus perhaps increased.
Yeah, which is the point I was making initially. Yeah. When you're looking at sort of the 25,000 sort of profit, if you're looking at it purely from a cash point of view, it probably isn't the right decision, because those tax savings are more than outweighed by the extra costs that you will incur, quite often professional fees and accountants' fees, because your accounts have got to be in a certain format, for example, whereas with a sole trader they're a lot simpler. But it's one of the factors. If you're looking, if the risk issue is a big issue to you, then the tax angle is a bit is secondary, and it's a price that you're going to have to pay to go corporate. Yeah,
I mean, just from a personal viewpoint, if I'm dealing with an unincorporated business and charging them, say, £1,000 a year for accountancy fees, if they were limited, it would probably be, say, 15, 16, 100 quid. Yeah. Because you're then faced with a 10-page set of accounts rather than a 2 or 3 page set. Plus, it's got to be compliant with the 06 Companies Act and this sort of stuff. So, but what I would never do, and Chris would be the same, is to advise a client, oh yeah, you can save this amount of tax, but we'll snaffle it all in extra fees. Assuming there's, as Chris said, there's no other drivers behind it, like the limited liability or needing to be corporate to have this sort of a bit more credibility dealing with bigger customers. So I think the moral is always talk to your accountant before you decide to do anything like this and to get their view on it. So thanks very much, Chris. Over to Paul now, and obviously you'll be touching on shareholders agreements and other aspects of sort of commercial, corporate commercial work. So Paul, over to you.
Thank you, Patrick, and thanks very much for that very kind introduction and for the testimonial. I shall have to go back to my website and see who wrote that. Yeah, so Andrew and I worked together a couple of years ago, probably a bit more than that now, but Andrew did some sterling work for me, and thank you for that, Andrew. And our minds were aligned on this subject. I think we both of us thought of it independently. Now is a good time to think about governance in the broad context, or as Andrew puts it in this in his service, the business resilience. And a key part of that is putting together your agreement. So this is the slide I've got for everyone to have a look at. Hopefully, it will help illustrate my talk. That is, if I can get it to work. I think I'll do that, yeah. So, can I just check everyone can see that?
Yep.
You should see without an agreement at the top.
Yep.
Yeah, okay.
Perfect.
So, yeah, this talk is about what happens if you don't have an agreement. So the very first thing that I will ask if you come to me and ask for advice is, do you have an agreement? And if your answer is no, I will say, are you absolutely sure about that? Because I really want you to have an agreement. And I will ask you to check out anything that you might have written down, any emails, anything that will help me to advise you, because really without an agreement, you are at sea, all at sea. And you'll see why in a sec. So the key message here, and I just wanted, we have done, as I said, we've been working, Heleth and I have been working on this idea of business life planning, and actually done a few talks around what does a shareholders agreement look like, and features of business life planning. So do come and talk to us. We've got videos, looking at what does an agreement look like. In the time that I've got available for this talk, I thought I would just concentrate on what happens if you don't have an agreement, really to make the point that you should get one. So let's have a look. So I thought we'd start with just looking at the event, what I call forcing an exit. You could call it getting paid your share and the value of the business. You could call it cutting your losses. How do you do that if you are in a company, in an LLP, or in a general partnership? So let's start with the company. And by and large, certainly in my experience, this is where most corporate vehicles are, or business vehicles are, in the form of a private company limited by shares, and that's really what I'm talking about here. So if we imagine that you are a shareholder with other shareholders in a company, and you want to, you have an offer, you have somebody who's interested in buying, a third-party buyer. Now the question is, can you as a single shareholder sell the company? Well, the answer is no, you can't. You can only sell your shares in the company. The exception to the rule is what they call a squeeze out, and that's provided by the Companies Act, which provides that if an offer is accepted by 90% plus of a class of shares, and it has to be per class, you can squeeze out the minority. So typically what you would do with a shareholders agreement is you will set, you would incorporate what they call drag and tag rights, which is to say, if an offer comes along, bona fide a third party offer for the company, and a certain majority is reached, and you can set that majority yourself by agreement. So it could be, I've seen as low as 60%, sometimes 55% even, up to say 75%, or maybe 70%. You look at the individuals in your company, you think, if so-and-so and so-and-so, perhaps two other people are backing this deal, then really I'm happy, and everyone else should be happy with it too. So that is the drag and tag. If the only other exception you've got there is if you have to cut your losses, and you need to liquidate the company. But of course, 75%, as you see there on the slide, liquidation produces a very poor return for shareholders, so it's not ideal. So again, you might want to work out ways in which that can be addressed, so that if you cannot agree on a way forward within the company, say a deadlock arises, that you decide, yeah, look, if we have a complete impasse on an issue, then we need a deadlock resolution, and that might mean ultimately allowing the company to be wound up. That's typical sort of structure for a joint venture. Then you've got the LLP. Now the LLP is even more difficult, as it were, in this area. An LLP works the way I describe an LLP is it works like a partnership on the inside, and it acts like a company on the outside. So it is, and it's one of those hybrids. LLP, for those who don't know, limited liability partnership. As you can see by the slide there, you can only force an exit by court order. And essentially, you need to prove some form of unfair prejudice to get there. You can resign, but there is, again, just this, if ever you do find yourself in this situation, you'll be disheartened to get the next bit of advice I'm going to give you, which is that the courts have considered this, and there's no clear answer as to whether or not you get any value back if you were to resign. Looking at partnerships, many people don't realize that a general partnership can be terminated immediately by notice, and that notice need not be in writing. You can simply say, I'm quitting, I'm out. But there is no right to retire, in inverted commas. And what I mean by that is there's no right for, say you had 3 partners, for one of those partners to leave and leave the other 2 partners to run the partnership. That is, if you haven't got an agreement. So what will happen is if one partner, inverted commas, retires, that actually terminates the entire partnership. And that can have bad tax consequences for you, as Chris will be able to advise. So essentially, it closes the partnership, and a new partnership starts up between the 2 that want to continue. But when you're advising partners in a partnership, and we see this quite a lot with farming partnerships and husbands and wives who become partners, where the husbands and wives break up, there's a termination of the partnership, and a new partnership is then created without them realizing that's what's happened. So even if they've got a partnership agreement for the old partnership agreement, if it's not properly worded and it hasn't been properly operated, you can find yourself in a situation when you haven't got an agreement. Looking at the next question is, can you be forced out? Another key issue. And by forced out, I've looked at 2 levels here, if you like. One is forced out of management, and can you be forced? Can you be required to be paid out your value in the business? So there are 2 levels here. That doesn't apply quite so much to LLPs and partnerships, where effectively you're both a partner is both a manager and an owner, all rolled into one. But if we look at companies initially, you could be a director and dismissed as a director, and you could be left. You could find that your shares are left behind. You simply cannot. There's no right to sell them. So yes, if you've got this is written into the Companies Act, that no agreement, in fact, can provide that can get around this rule, which is that a 50% majority can dismiss directors. So turning it on its head, we talked about directors' duties. Those are owed to the shareholders and general meeting acting by majority resolution. So ultimately, the board is accountable to the 50% plus shareholders, and the 50% shareholders can dismiss them. But that doesn't mean to say you get your money out. As I've said, in those circumstances, you could just be left high and dry with these shares, which might not be particularly valuable percentage in terms of the voting control in the company, with no buyers and no opportunity to sell. Equally, there's no obligation to sell them. So if you turn this all around and you're thinking you're forcing somebody out, then they can keep their shares. So it can work in a bad way, both ways, if you see what I mean. So again, a well-drafted shareholders agreement is going to address that. It's going to give the opportunity to the continuing shareholders to buy out that director's shares at a fair price. And it could be at a fair price, or it could be, this is where it can get quite convoluted, but you can start talking about things like good levers and bad levers. and the circumstances in which you are dismissed. And typically, where there's some sort of blame, you would expect, if you're talking about bad leavers and good leavers, that the price for your shares will be marked down. Again, I haven't got time enough really to go into that detail, but it's a very interesting and rich subject for discussion, and one that really helps to establish the boundaries and the relationships between the parties when they go into these sorts of arrangements. So LLP, there's no right to expel, as you can see there. And again, you've got application to court is required. So that means you're locked into that LLP with those other partners. That's assuming you're the person who wants to get rid of somebody. Again, with a general partnership, no right to expel, but you can terminate. So again, it's a very blunt instrument. You have to bring the entire partnership to an end just to get rid of one person. So what happens on death? Now, I think it follows from what I've just said here that if you were to die as a shareholder director of a company, yes, you would no longer be a director of that company. That would be immediate. But equally, you have no right to be bought out. So one of the things you can think about here is what they call cross options, and that is where you create a right to be bought out of the proceeds of a life assurance policy. Again, Andrew can help you with some of that. That gives the opportunity for your estate to benefit from the value of those shares, and for the ongoing shareholders to have your shares back into the company. With an LLP, that terminates the membership. Again, like resignation, in other words, there's no guarantee you'll get anything out at that point. So again, you need an LLP agreement at this point to say what happens on death. You would expect, therefore, that you would get your capital investment out, and you might, depending what you agree, get something of the goodwill of the partnership out as well. And the same applies to partnership. Again, a well-worded partnership agreement will address what happens on death and how you get your share of the capital, your share of the profits, and your share of any goodwill. Partnerships don't always value goodwill, so that's one for discussion. But it would at least address all those issues. Critical, obviously, if you're thinking as you perhaps are thinking, what do I get out of this if I leave? And finally, let me just talk about incapacity. So what happens if you're not able to continue? Well, if you're in a company, that will terminate your directorship, but nothing else. So again, if we think about it from the point of view of the continuing shareholders, that might not be what they'd want. They might actually want to buy you out at that point. And again, if we go back to that thinking about good leaver and bad leaver, typically incapacity would be a good leaver event. In other words, they would pay you fair value in those circumstances if you were incapacitated. And that serves both parties, doesn't it? It means that the shares are recycled into the company and you get the value of those shares out at fair value. Again, an insurance policy can help there, gives you that extra bit of cash that can be used to buy out those shares. With an LLP, incapacity has no effect on membership. That person continues. Now, that really may not be what you want because you've got a non-working partner in the business at that point. And you'll see that if you want to get that person out, you're talking about, potentially winding up the affairs of the company and dissolving it. Again, a convoluted process which may not produce the best value for the assets in the business. And you will see, even after all that, you still need a percentage to get for the LLP to be dissolved. By dissolved, I mean cease to exist. Again, if you're incapacitated, there's no effect on the partnership, a general partnership, but the court may order dissolution. So you need to go to court to get it dissolved. Again, you would want a right in those circumstances to call it a day with your partner and to pay out that partner's share. So those are the key elements that I would expect to see in well-drafted documents covering each of those three types of organization. It's a bit of a canter through, but that's my talk. I'm going to leave the slides up because I think Heleth mentioned you might want to talk to them as well. I'm going to pass back to Patrick.
Okay, thanks, Paul. Yeah, you can leave the slide up there. Just one question I'd ask, actually, something I see a lot, and possibly Chris as well, with a lot of new companies, and perhaps they haven't actually elicited our advice first, and they go and form their own company. You know, typically you have one class of share, or Director A has one, and Director B has another. I mean, does that make your heart sink if you see that? So they've got 50% each, you know, the same class of share, and you just think, oh God, you know, the kind of potential issues that sort of may arise from that.
Well, I think always the first question I would say is, how well do you get on in that event? Because if people are getting on, well, okay, they could probably work it out. But even there, two partners, they were in a company, but they were regarded themselves as partners. And one of the partners died, leaving it to his then estranged, divorced, I think, wife. And it was very difficult for the surviving partner to get those shares back. Very difficult. It's very emotional. All sorts of issues running around about and sadness. You know, he died young, so it would have been very much more helpful had there been an agreement which addressed it. Sorry, Chris.
Yeah. I just think the other thing there is all very well asking how people get on now. I've seen on more than one occasion, in 5 or 10 years' time, they're not talking to each other. So you know, you've got to be prepared for all eventualities, I think. So
I was going to say, if they come to me and they've said they've fallen out, that is really where my heart sinks, because you've got to start working out, well, who is going to go forward with this company if either of them are, who's going to buy out who, and how is it to be resolved? And that can be very expensive indeed.
Yes, and I think
absolutely.
That sort of brings me to another point. I mean, it's all very well saying, and I've said to clients, well, you know, it's that old adage, isn't it? You fix the roof while the sun's shining. So while you're getting on, now's the time to put in a shareholders agreement. But they come back and say, oh, well, we've only just started, you know, cash flow's a bit tight, blah-de-blah. And accepting your point that actually it might cost them a lot more further down the line. But can you give us a rough idea? I know it's how long's a piece of string, but on the kind of costs, you know, a small company perhaps is thinking about in terms of the cost of setting up or getting a shareholders agreement drafted, perhaps.
Yes, it is difficult, because the first thing you need to do is work out how much initial guidance is required, how much shaping, how much initial discussion to get you to a point where you're ready to start drafting. But essentially, if and we do them for typically 15. Well, our starter pack is 1,250, and I would say you could double that if you wanted a reasonable range, and that would cover probably 80% of all shareholder agreements that we do. There are ones that come out a lot more expensive than that. Not many that come out cheaper. It very much depends. You know, if you wanted a very pared down version, it might be slightly cheaper. But generally, you know, if you're an established business, profitable business where there's quite a lot at stake, and perhaps lots of partners. The one we did with your firm, in fact, there were something in the order of 10 shareholders. So, you know, by the time you've weighed all that up, it does begin to get much more expensive than that. But if you're talking about 2 to 3 shareholders, maybe 4, then that range I gave you would pretty much do it.
Okay, that's good to know. Right, we've kept her waiting long enough. So, Helid, if I can pass over to you. Obviously, you're still on mute at the moment.
There you go. There we are. All good. Yeah, great. Thank you very much. So I would echo all the things that have been said all along. That sort of planning is better than crisis management. Nobody likes to think about a future where things aren't rosy, but you bet your bottom dollar that if if it goes wrong, it's going to go wrong in a pretty spectacular fashion. And nobody, it's the emotion, it's the distress, and nobody likes a distress purchase. So very much everybody here today is talking about, let's get the scaffolding right, let's get the structure right, and then you can go away and do actually what you want to be doing. So you're in business because you're enjoying your business, you're doing what you're good at, you're really enjoying it, and you want to be able to have the freedom and peace of mind to do that. So where I come in at this point is saying, well, businesses are run by people, and people have personal lives, business lives, and whilst we try and keep them separate wherever possible, sometimes things do intervene that means that we need to have a look at that personal life and how that interacts with the business life. So I'm really going to talk about the two parts of Paul's slides that concentrate on the death and incapacity. So death, nobody wants to think about it, but in a sense, actually, it's probably more straightforward because you can't be half dead, So if somebody dies, they're dead. They are no longer a part of the business. They are no longer able to interfere or make decisions, but they still own a share, whether it's in a company or an LLP. They've still got a vested interest in what's happened to that. So what does their will say? Does anybody know? Or actually, is there a will? Even better. So what this document is actually pretty important. If somebody drops down dead, unfortunately, that asset that they own, all their personal stuff will need to go under the terms of the will, but also their business assets. Setting up a will that interacts with your company, partnership, LLP paperwork is crucial. Again, working with Paul and Andrew on a complex sort of multi-family, multi-shareholder client base, we've had really interesting conversations about who wants to do what with which bit, and we've worked together and we have achieved a great outcome, I think, for them, because everybody's got their ducks in a row now. So wills are really important. They are, people just think, oh, they're bits of paper. Well, actually, they're bits of paper that might have a massive impact. If you're in a company and your major shareholder dies and everything goes to a child, what then? How does that work? What's the impact? That's going to get complicated. To give you sort of a real disaster case that I dealt with, and as lawyers, we do tend to get called in at the worst time. And I swear you couldn't make this up. So we had a phone call one morning and there were two brothers, farmers, in partnership, as was the case. One had punched the other one and killed him. Now, utterly awful circumstances. So we had one brother he'd been in a coma for about 10 days. His brother was not allowed within 30 miles of the farm because he was on bail. There were children running the farm, which was a dairy farm of about 200 cows and a caravan park, and nobody had access to the paperwork to keep this business going. And ultimately, and this really is why I sort of very much like to talk about this, is say that business was destroyed within 6 months because nobody was able to quick enough step up to sign the contracts, to look at the agreements for the rentals in the caravan site, to sell the livestock, to sell the dead stock. When you've got one partner who is incapacitated, then dead, and the other one who is not allowed within 30 miles of the farm, what then? These things don't just stop. And on that occasion, the will did leave things to a child. And then thankfully, the child was nearly 18. So we were able to wait long enough to get them to be able to sign some paperwork and move things around. But had they been 4, 5, 6, that would have been court proceedings, and that would have added huge amounts of extra cost. Never mind the distress that you can imagine that this family went through. So really thinking about, if somebody dies, what then, is really important, because it does happen. Nobody wants it to happen, and you certainly don't want it to happen to you, because the emotional impact as well as the financial impact is significant. But in a sense, as I said at the beginning, death is quite straightforward. It's sort of on or off. Incapacity, which is the other concern that you might have, can actually be more complicated. So incapacity could be anything. Incapacity could be going skiing like Michael Schumacher and being in a coma for 3, 4, 5+ years. There's a massive amount of uncertainty there. Are they going to come out of it? If they come out of it, will they be able to still be involved in the business? Is this temporary? Is this permanent? Incapacity can be things like we've got somebody who's got early onset dementia. Are they making decisions in the business that are perhaps a little bit off, a little bit strange? Actually, what then? What happens if you've got somebody who is still physically with us, but actually is unable and incapable of making business decisions? Where does that leave you? That's a massive uncertainty. So looking at, again, the terms of your paperwork, what happens if you have an incapacitated director? What happens if one of your partners is in a coma for 3, 4, 5 months, but comes out of it? Or is it anticipated to come out of it? Can you afford to leave that decision making for that period, for that lacuna of time? So what can you do about it? Well, you can, depending on, again, the structure of your business, and Paul's set out the sort of 3 main feelings out. We're very much talking about get business powers of attorney in place, get your team in place. If you are unable to act for whatever reason, who's your backup? Who's going to be in your corner saying what you want? Who are you going to nominate to be that person? Now, depending again on the structure of the business, it's different people can and should be involved. But really, what you're really doing is saying, I've got an insurance policy. If, God forbid, something happens, I know I've got my team together to do that. So really, to sort of round up everything I think that I've said and there's been said is we've all worked too hard to get where we are professionally. We've all worked too hard in business to just not plan for potential crises such as death, incapacity, being forced out, forced exit. So get your team together, have the conversation, and I think probably loop back to what Andrew was saying right at the beginning. It's this planning. What can we do, and how do we achieve it together? So back to you.
Yeah, thanks, Helen. I think 2 things come from that. I think firstly, I think there's a reason I don't tend to encourage farming clients and myself. And secondly, I think Helen would make an ideal dinner party guest with all the stories you could possibly trust. But I mean, to be serious, actually, just also I'd sort of obviously put Paul on the spot a bit with the costings. And how much typically, and again, accepting how long's a piece of string, to set up a will and a power of attorney, do you think?
Yeah, no problem at all. So, I mean, depending on the complexity of family structure and what's going on behind the scenes, I mean, if you've got a husband and wife want to leave everything to the surviving spouse, down to the kids, nice and straightforward, no real issues there, you're talking about £600. If you want better protection, if you want to make sure you're tax efficient, you're efficient for potential care fees, and I've got another horror story on care fees and farming, that's for another day. That we're going up, again, Paul said probably double, triple that. But to think that you could then save in the future, as one of my farming clients did, we saved them 70, 80, £100,000 in care fees from a properly structured will. I think that's £1,200 well spent.
Yes, and what, I mean, you said it when we were sort of in the preparation for this webinar, but what would you say to somebody who say, oh, well, I can do my own will online? And I think you had a dental reference, didn't you?
Oh, I may have said you can also pull your own teeth out.
That's the one. That's the one. So I think, thank you very much for that. I think we are running out of time. I will. We've covered a lot of the questions. I know there's one question from Amy that we haven't covered, but we'll cover that separately, Amy, if you're watching, if we may. I'll just pass back to Andrew now, just for the final piece on this, the business resilience service. So Andrew, over to you.
Yes, thank you, Patrick. Thank you, everybody, so far. Yes, really just to kind of reiterate, I'm not going to get you to screen share again, don't worry, I'll just chat to you all. The whole purpose of this service, if you like, is to bring together a package of professionals that can help you as business owners or professionals yourself, bring some structure to the business that you operate on a day-to-day basis. So it is very much about working on it as well as working in it, taking some time out, and I think potentially alluding to something that Chris said, making the business more attractive if ever you're going to sell it and not just pass it down to your family. So it makes it more saleable, potentially more palatable to other business partners. It definitely does that. But I think for me, as a financial planner, the crucial thing that having a plan gives you is a degree of comfort and degree of certainty of outcome, rather than just hoping for the best. You know, we do that too. We plan for the worst as well as hoping for the best. So that will include quite a suite of protection arrangements. They're all alluded to in the service. We'll be sending you the leaflet so you can have a look at it. I don't want to keep you too long and talk through them all individually, but just very briefly, a couple of highlights alluding to Paul's section. Obviously, if you're sensible enough to put in place a proper partnership or shareholder agreement, you then need partnership or shareholder protection, so that if somebody does die or fall critically ill, you have the means to buy them out of the business quickly and cleanly. It's not even particularly expensive. Relevant life plans are another classic one. Lots of our business owners that run companies are paying for their life cover personally, where the company could be paying for it for them without a P11D tax charge and giving a reduction in corporation tax. So transfer the cost of providing for your personal life cover from your own cost to that of your company. And then others, key areas, key person insurance. HMRC allow you to mitigate against the impact on your profit of a key person dying. You'll all have them. If you don't have them, have a think. You will all have them. Key people, if they die or they have a critical illness, it can be catastrophic to a business. The cost of recruitment, retraining, loss of potential custom and so on and so forth, you're allowed to protect against it, so protect against it. It's not even particularly expensive. And then of course, the things we don't particularly like talking about, what happens if you suffer a critical illness? Well, that's what critical illness cover is for. Income protection insurance is another example. If we're unable to work, you can have a policy that's permanent that can pay out on multiple occasions to replace your income if you can't work. And all of these things combined with having the right business structure, courtesy of Chris, proper wills and powers of attorney in place, courtesy of Heled, partnership agreement, and a bit of help from me on bringing it all together, because after all, I'm a financial planner, that's what we do. We come up with the overall plan, should give you an awful lot of comfort that if and when the worst happens, you'll be far better positioned than you are at the moment. And that's it. That's what it's all about.
Thank you, Andrew. That's lovely. Yeah. Well, I'll wrap it up there. We're on the cusp of 3 o'clock. So yeah, what I would say is, sorry if we haven't got to your questions. I think we've covered quite a lot though. If you still want to ask a question, as I said earlier, you still can. events@thomaswestcott.co.uk. Can be for any of us. We'll pass them on to Helen and Paul if appropriate, or if you're a client of TW, your usual partner will probably attend to them. I would like to thank our speakers today, Andrew and Chris, but especially Helen and Paul. I think they've been great, and hopefully you, our attendees, have got a lot from it. Thank you very much for watching. There'll be another TW webinar in due course, so look out for that. Have a great rest of the week, and as always, embracing my inner Ron Burgundy. Stay safe, Devon and Somerset and Bristol. So yeah, that's all. Cheers.